29th April 2014, Oklahoma State Penitentiary. At 6:23 in the evening, the execution of Clayton Lockett begins. The state protocol calls for a 3-drug sequence: unconsciousness in seconds, death within minutes. Witnesses crowd the viewing chamber. The victim's family sits front row, waiting for the closure they were promised. But 43 minutes later, Lockett remains alive, writhing on the gurney. The warden closes the blinds. Execution's promised finality. The record shows something different: experimental drug cocktails, untested protocols, prolonged suffering that sparked national outcry. 7 botched executions across 5 states would expose a system in crisis, where the line between justice and cruelty blurred in execution chambers, each case documented, each failure measured in minutes and legal consequences. This is the story of how America's death penalty protocols broke down, one execution at a time. Oklahoma Execution Protocol Document, State Filing Outlining Lethal Injection Procedures, 13th December 2006. Florida State Prison. The execution chamber holds a single gurney under fluorescent lights. Outside, reporters check their watches. Protocol dictates 15 minutes maximum for a lethal injection execution. The state will use a 3-drug combination: sodium thiopental to induce unconsciousness, pancuronium bromide to paralyze, potassium chloride to stop the heart. Simple chemistry, predictable timeline. Angel Diaz lies on the table. The execution team inserts catheters into both arms. Standard procedure. At 6:22 in the evening, they begin administering the first drug. Witnesses expect the familiar pattern: eyes closing, breathing slowing, then stillness. 4 minutes pass. Diaz does not lose consciousness. His eyes remain open. His jaw tightens. 7 minutes, 10 minutes. Witnesses shift in their seats. At 24 minutes, Diaz grimaces. His lips move. He appears to be mouthing words. The execution team administers a second complete dose of all 3 drugs. This almost never happens. The protocol assumes 1 cycle will suffice. At 34 minutes, more than twice the expected duration, medical personnel finally declare Diaz dead. The autopsy reveals why. The IV catheters penetrated completely through the veins in both arms, pushing into the surrounding tissue. The drugs entered subcutaneous flesh instead of bloodstream. Medical examiners document chemical burns extending 30 centimeters on both arms. The top layer of skin separated from underlying tissue, a condition called skin slippage. Sodium thiopental, when injected into tissue rather than veins, provides no anesthesia. Diaz likely remained conscious as paralytic drugs prevented him from breathing. Governor Jeb Bush orders an immediate moratorium on all Florida executions. He convenes a commission to review lethal injection procedures. The state's medical examiner concludes that the execution involved negligence in the placement of needles. Florida had previously used the electric chair. 3 executions resulted in visible burning, smoke, and in one case, flames. The state switched to lethal injection in 2000, believing it would be more humane. Diaz became the 20th person Florida executed by injection. His death revealed that changing methods did not eliminate risk. It merely shifted the nature of potential failure from electrical to chemical. The Diaz execution file contains 47 pages of incident reports. One line stands out. Subject continued to show signs of movement at approximately 24 minutes post-injection. In execution documentation, such phrases represent policy failure measured in human distress. What had gone wrong? The execution team lacked medical training. Florida law prohibited licensed medical professionals from participating in executions. The insertion of IV lines, a procedure requiring skill and anatomical knowledge, fell to corrections officers following a written protocol. When the needles missed their targets, no one in the chamber possessed the expertise to recognize the error or correct it. State Department of Corrections Investigation Report, Oklahoma's Internal Review of Execution Failure, 29th April 2014. Oklahoma. The Lockett file opens with a 3-word notation on the cover: execution halted, incomplete. Such language appears nowhere else in Oklahoma's execution records. Every previous death warrant since the state adopted lethal injection in 1990 had concluded with a single outcome: time of death recorded, body removed, file closed. Clayton Lockett was sentenced to death in 2000 for the 1999 murder of 19-year-old Stephanie Neiman. The Oklahoma Supreme Court upheld the conviction. Federal habeas corpus review found no constitutional violations. The clemency board denied relief. The execution date arrived after 15 years of appeals. Oklahoma planned a double execution that evening, Lockett at 6, followed by Charles Warner 2 hours later. Both men had challenged the state's refusal to disclose the source of execution drugs. The Oklahoma Supreme Court initially stayed both executions pending resolution of the drug secrecy issue. Then, the state legislature threatened to impeach justices who voted for the stay. The court withdrew its order. The executions would proceed. The execution team began preparing Lockett at 5:45 in the evening. They needed to establish IV access, insert catheters into veins that would deliver the 3-drug sequence. The protocol required 2 IV lines, 1 in each arm, for redundancy. The first attempt failed. The paramedic could not locate a viable vein. Lockett had a history of intravenous drug use. Scar tissue complicated the process. A physician tried accessing the jugular vein in Lockett's neck. Failed. They attempted subclavian access through the collarbone. Failed again. Lockett, fully conscious throughout, eventually spoke. "I've got a vein in my right leg." The paramedic expressed reluctance. Leg veins carry higher risk of blood clots. Lockett responded, according to transcripts, "Does it really matter?" The team finally established a femoral line in Lockett's groin at 6:18 in the evening. They covered the area with a sheet to protect his dignity. This meant the IV insertion site was no longer visible to the physician monitoring the procedure. At 6:23, they administered midazolam, a sedative intended to render Lockett unconscious. At 6:33, a physician declared him unconscious. 3 minutes later, Lockett began moving. His head lifted. He spoke the word "man." Witnesses described convulsive movements. At 7:06, Lockett died of a heart attack. The total elapsed time, 43 minutes from first injection to death. Director of Corrections, Robert Patton, immediately halted Warner's execution scheduled for 8 o'clock. The subsequent investigation found that the femoral IV line had infiltrated. The catheter tip resided in tissue adjacent to the vein, not within it. Drugs entered Lockett's groin muscle. Without direct bloodstream access, midazolam could not induce unconsciousness. The paralytic and potassium chloride drugs then caused death, while Lockett remained at least partially aware. Governor Mary Fallin ordered a review of all execution protocols. The report appeared 4 months later. It identified IV access viability as the single greatest contributing factor to the execution failure. Oklahoma had executed 107 people since 1990. None had required more than 20 minutes. Lockett's 43-minute ordeal represented not a minor deviation, but a fundamental protocol breakdown. The state's execution manual assumed successful IV placement. It contained no contingency procedures for vein access failure. Death penalty expert Deborah Deno, a law professor at Fordham, called it one of the worst botches that we've had. All of this was predictable and foreseeable. Federal court filings, defense motion challenging drug protocol constitutionality, 16th January 2014. Southern Ohio Correctional Facility, Lucasville. Dennis McGuire enters the execution chamber at 10:06 in the morning. He had been convicted in 1994 for the 1989 rape and murder of Joy Stewart, who was 30 weeks pregnant. The jury deliberated less than 4 hours before recommending death. The Ohio Supreme Court affirmed. Federal courts denied habeas relief. The clemency board recommended against commutation. Ohio faced a drug shortage. European pharmaceutical companies had banned sales of execution drugs to United States prisons. Denmark-based Lundbeck, manufacturer of pentobarbital, the previous execution drug, prohibited American departments of correction from purchasing its product. Ohio exhausted its pentobarbital supply in September 2013. The state needed an alternative protocol. Officials selected a 2-drug combination never before used in any American execution: midazolam as a sedative, hydromorphone as an analgesic. Both drugs were legally available. Neither had been tested for execution purposes. No medical literature established proper dosages for inducing death. McGuire's attorneys filed emergency motions arguing the untested combination would cause air hunger, a terrifying sensation of suffocation while conscious. They cited medical experts who warned midazolam might fail to produce adequate unconsciousness. An Ohio prosecutor responded bluntly in court, "The Eighth Amendment does not guarantee a painless execution, only one free from intentional cruelty." A judge allowed the execution to proceed. At 10:27, prison staff administered both drugs intravenously. McGuire closed his eyes. For 3 minutes, observers noted no movement. Then, at 10:31, his stomach began to rise and fall in exaggerated movements. His mouth opened wide. He gasped, a deep guttural sound that one reporter compared to a fish gulping for air. The gasping continued and continued. Minutes passed. McGuire's chest heaved. He made snorting and choking sounds audible throughout the viewing chamber. His fists clenched. The sounds persisted for at least 10 minutes, possibly longer. Witnesses gave varying time estimates. Some described the noises as snoring. Others characterized them as signs of distress. At 10:53, 26 minutes after the drugs were administered, a physician declared McGuire dead. A typical Ohio execution lasted 8 minutes. McGuire's took more than 3 times longer. It became the longest execution in Ohio history. Columbus Dispatch reporter Alan Johnson, who had witnessed 5 previous executions, told colleagues afterward, "This was not that. It started off looking as if it was going all right, but then obviously something didn't go right." McGuire's son, Dennis R. McGuire, and daughter Amber McGuire sat in the witness section throughout. They cried visibly. A priest sitting behind them attempted to console them. At one point, family members asked aloud, "How could this go on for so long?" Joy Stewart's family witnessed from the opposite viewing area. After the execution, Stewart's sister Jean Brown told reporters, "What I saw today with him being executed, it is nothing compared to what happened on August 7th, 1989. What's excruciating is seeing your father lying there in a pool of blood, seeing your sister lying in a pool of blood." Attorney Alan Bonert, representing McGuire's legal team, issued a statement. "At this point, it is entirely premature to consider this execution protocol to be anything other than a failed, agonizing experiment. The people of the state of Ohio should be appalled at what was done here today in all of our names." Governor John Kasich implemented an informal moratorium on executions pending a full review of Ohio's lethal injection procedures. The state attempted to locate alternative drug sources. Every inquiry failed. Pharmaceutical companies refused to sell execution drugs to state governments. Ohio conducted no further executions for 3.5 years. The McGuire execution demonstrated a paradox: transparency without certainty. Ohio had disclosed which drugs it would use. The execution proceeded with witnesses present and records maintained. Yet no one could answer definitively whether McGuire suffered, whether the drugs worked as intended, or whether the protocol could be safely replicated. 15th September 2009. Ohio State Penitentiary, Lucasville. Rommel Broom lies on the execution gurney. He was convicted in 1985 for the abduction, rape, and murder of 14-year-old Trina Middleton in East Cleveland. The crime occurred on 21st September 1984. Broom received a death sentence. Appeals proceeded through state and federal courts over 24 years. The execution protocol requires 2 IV lines. The team begins work at approximately 2 o'clock in the afternoon. Standard procedure expects IV placement within 15 minutes. The execution itself typically requires 10 minutes once drugs are administered. The first attempt fails. The needle cannot locate a vein. The execution team tries again and again. Broom's arms show evidence of old track marks. He had a history of intravenous drug use, complicating vein access. The team moves to his left arm, then back to his right. They attempt to place lines in both arms simultaneously. Time passes. 15 minutes becomes 30. Broom, fully conscious, attempts to help. He turns onto his side. He flexes his fingers and pumps his arm, trying to make veins more visible. He suggests locations the team might try. Witnesses later report that Broom cooperated throughout, seeking to expedite a process causing him obvious pain. The team tries his ankles. The needle strikes bone. Broom cries out. 40 minutes pass, then an hour. The team has now attempted 18 separate needle insertions across Broom's arms and legs. None successfully establishes a viable IV line capable of delivering the execution drugs. At 4 o'clock, 2 full hours after beginning, the execution team abandons the attempt. Governor Ted Strickland issues a 1-week reprieve. Corrections officials return Broom to his death row cell. He becomes the only person in modern American history to survive a lethal injection execution attempt. Broom's attorneys immediately file motions arguing that a second execution attempt would constitute cruel and unusual punishment prohibited by the Eighth Amendment. They also invoke the 5th and 14th Amendment protections against double jeopardy, being placed twice in peril of life for the same offense. The state responds that because no drugs entered Broom's system, his life was never actually at risk. The execution attempt, however traumatic, did not qualify as jeopardy in the constitutional sense. Federal District Judge Gregory Frost schedules hearings on whether Ohio can constitutionally make a second execution attempt. Amnesty International launches an international campaign highlighting Broom's case. Human rights organizations cite his experience as evidence of systemic failures in American execution practices. The legal battle continues for years. In March 2016, the Ohio Supreme Court rules 4-3 that the state may attempt to execute Broom again. The majority opinion concludes that, because Broom's life was never at risk since the drugs were not introduced, and because the state is committed to carrying out executions in a constitutional manner, we do not believe that it would shock the public's conscience to allow the state to carry out Broom's execution. 3 justices dissent, arguing that subjecting Broom to a second execution attempt after the trauma of the first would violate basic human dignity standards. The state schedules a new execution date for June 17, 2020. Governor Mike DeWine issues a reprieve on 14 April 2020, citing inability to obtain execution drugs. He reschedules the execution for 16 March 2022. Rommel Broom dies on 28 December 2020 at Franklin Medical Center in Columbus. The cause, suspected COVID-19 complications. He was 64 years old. He had spent 35 years on death row. The state never made a second execution attempt. Broom's attorneys Timothy Sweeney and Adele Schenk released a statement. He survived the 2009 execution only to live with the ever-increasing fear and distress that the same process would be used on him at his next execution date. Let his passing in this way, and not in the execution chamber, be the final word on whether a second attempt should ever have been considered. Witness statements, media testimony regarding execution observations, 23 July 2014, Arizona State Prison Complex, Florence. Joseph Wood is scheduled for execution at 1:52 in the afternoon. He was convicted in 1991 for the August 7, 1989 murders of Deborah Dietz, his former girlfriend, and her father, Eugene Dietz. Wood shot them at the auto body shop where Deborah worked. The jury recommended death. Arizona courts affirmed the conviction through multiple appeals. Arizona will use a 2-drug combination, midazolam and hydromorphone. This is the same protocol Ohio used for Dennis McGuire's execution 6 months earlier. That execution took 26 minutes and involved prolonged gasping. Arizona officials proceed despite the documented problems. Wood's attorneys file emergency motions requesting information about the drug source and the execution team's training. The United States Court of Appeals for the Ninth Circuit initially orders Arizona to disclose this information. The United States Supreme Court reverses that decision on 22 July, 1 day before the scheduled execution. The state may maintain secrecy. The execution begins at 1:52. Prison staff administer the drug combination intravenously. Wood closes his eyes. Observers anticipate death within approximately 10 minutes. At approximately 2:03, 11 minutes after drug administration, Wood's lip quivers. Then his mouth opens. He begins gasping. The sound resembles snoring to some witnesses. Others describe it as labored breathing. Reporter Troy Hayden of Fox 10 News later tells colleagues it sounded like a fish on shore gulping for air. The gasping continues. Minutes accumulate. Wood's chest rises and falls in exaggerated movements. Prison officials enter the chamber 7 separate times to check his level of sedation. Each time they determine he remains deeply unconscious, yet the gasping persists. At 2:52, 1 hour after the execution began, Wood's attorneys file an emergency motion with the Arizona Supreme Court. The motion states, he has been gasping and snorting for more than an hour. He is still alive. This execution has violated Mr. Wood's 8th Amendment right to be executed in the absence of cruel and unusual punishment. We respectfully request that this court stop the execution and require that the Department of Corrections use the life-saving provisions required in its protocol. Before any court can rule, the process concludes. At 3:49, 1 hour and 57 minutes after the execution began, a physician declares Wood dead. The total duration makes it the longest execution in United States history. Corrections logs reveal that executioners administered 15 separate doses of the drug combination, far exceeding the single dose the protocol anticipated. Each time Wood's breathing continued, the team injected more drugs. They improvised without precedent or medical guidance. Reporter Michael Kiefer of the Arizona Republic, who had witnessed 5 previous executions, said afterward, "Usually it takes about 10 minutes. The person goes to sleep. This was not that. It started off looking as if it was going all right, but then obviously something didn't go right. It took 2 hours." Dale Bache, Wood's federal public defender, issued a statement. "I've witnessed a number of executions before, and I've never seen anything like this, nor has an execution that I observed taken this long. The state of Arizona today conducted a failed experiment." Deborah Dietz's sister Jean Brown addressed reporters after the execution. "What I saw today with him being executed, it is nothing compared to what happened on August 7th, 1989. What's excruciating is seeing your father lying there in a pool of blood, seeing your sister lying in a pool of blood." Governor Jan Brewer ordered an investigation, but maintained that Wood died in a lawful manner, and by eyewitness and medical accounts, he did not suffer. This is in stark comparison to the gruesome, vicious suffering that he inflicted on his 2 victims. Arizona implemented a temporary moratorium on executions pending review of its procedures. The state conducted no further executions for 8 years, until May 11, 2022. An independent investigation later concluded that Wood likely remained sedated throughout. Medical experts disagreed about whether the gasping indicated consciousness or merely reflected involuntary reflex actions. The conflicting interpretations highlighted a fundamental problem. When execution procedures fail, determining whether the condemned person suffers becomes a matter of medical speculation rather than objective certainty. Death Penalty Information Center. Statistical Report, Botched Execution Rates and Trends. The numbers tell a story of systemic failure. Between 2006 and 2014, 7 major execution attempts resulted in documented complications prolonged enough to spark investigations, legal challenges, or policy changes. Angel Diaz in Florida, 34 minutes, chemical burns, second drug dose required. Rommel Broom in Ohio, 2 hours of needle insertion attempts, 18 injection sites, execution abandoned. Dennis McGuire in Ohio, 26 minutes, continuous gasping for at least 10 minutes. Clayton Lockett in Oklahoma, 43 minutes, multiple vein access failures, death by heart attack after execution halted. Joseph Wood in Arizona, 1 hour, 57 minutes, more than 600 gasps, 15 drug doses. These 5 cases share common elements. Each state used relatively new drug protocols. Each faced pharmaceutical company refusals to supply traditional execution drugs. Each execution team lacked comprehensive medical training. Each resulted in durations far exceeding protocol expectations. The Death Penalty Information Center, which maintains execution data, designated 2014 as a watershed year. 4 separate botched executions occurred within 9 months. Republican Senator John McCain called them torture. Media coverage intensified, legal challenges multiplied. Compare this to prior decades. Between 1977, when lethal injection began, and 2005, botched executions occurred but garnered limited attention. The public and courts generally dismissed them as isolated aberrations. The system remained temporarily out of order, but not fundamentally flawed. After 2014, perception shifted. Botched executions became evidence of systemic inadequacy rather than random failures. The problems appeared structural, not incidental. Consider the protocols. States traditionally used sodium thiopental, a barbiturate that reliably induced unconsciousness. When American manufacturers stopped producing it, states switched to pentobarbital. When that became unavailable, states experimented with midazolam, a drug that medical literature indicated might not reliably produce the deep unconsciousness required for execution. The midazolam cases, Lockett, McGuire, Wood, all involved prolonged executions with visible signs of distress. Yet states continued using the drug because alternatives did not exist. The choice became use questionable drugs or halt executions entirely. Several states chose the latter. Pennsylvania, California, Oregon, and Washington imposed moratoria. Other states simply stopped scheduling executions while they searched for reliable drug sources. Between 2015 and 2019, the number of annual American executions dropped to levels not seen since 1991. The legal landscape changed. Defense attorneys began challenging not just whether clients deserved death sentences, but whether states could administer them without violating Eighth Amendment prohibitions on cruel and unusual punishment. Courts had to evaluate not abstract questions about capital punishment's morality, but concrete questions about specific drug protocols' reliability. In January 2022, the Death Penalty Information Center published its annual report, the title, The Year of the Botched Execution. 7 of that year's 20 execution attempts, 35%, were visibly problematic. The report attributed difficulties to executioner incompetence, failures to follow protocols, or defects in the protocols themselves. These statistics represent policy failure measured in minutes and human suffering. Each botched execution emerges from decisions made years earlier: legislative choices to maintain capital punishment, correctional decisions about drug selection, judicial rulings on disclosure requirements, corporate policies on pharmaceutical sales. The question facing jurisdictions became not whether to execute, but whether they possessed the capacity to do so in a manner consistent with constitutional requirements and basic human dignity standards. Supreme Court Opinion Excerpt, Federal Review of Execution Protocol Challenges, Glossip verua Gross. The Supreme Court case emerged directly from Oklahoma's botched executions. Richard Glossip and other Oklahoma death row prisoners challenged the state's use of midazolam as the first drug in its 3-drug protocol. They argued midazolam could not reliably produce unconsciousness deep enough to prevent suffering when subsequent drugs were administered. The case reached oral arguments on 29 April 2015, exactly 1 year after Clayton Lockett's execution. Attorneys presented medical evidence about midazolam's pharmacological properties. They cited the Lockett, McGuire, and Wood executions as proof the drug failed to work as intended. Oklahoma and its supporting states argued that prisoners challenging execution protocols bore the burden of identifying a known and available alternative method. Merely showing problems with the current protocol was insufficient. Prisoners must propose a different feasible approach. On 29 June 2015, the court issued its decision. 5-4, it upheld Oklahoma's protocol. Justice Samuel Alito wrote for the majority. He acknowledged that some witnesses described disturbing events during the Lockett and Wood executions. However, he concluded that expert testimony supporting midazolam's effectiveness, combined with its successful use in some executions, satisfied constitutional requirements. Justice Sonia Sotomayor wrote a dissenting opinion joined by Justices Ruth Bader Ginsburg, Elena Kagan, and Stephen Breyer. Her opinion quoted extensively from the Lockett execution record. The Lockett execution went poorly, to say the least, she wrote. She reviewed the timeline, the vein access problems, the visible distress, the decision to close the viewing room blinds, the eventual death by heart attack. Sotomayor argued the majority opinion placed impossible burdens on prisoners. How could inmates identify alternative execution methods when states maintained secrecy about drug sources? How could they prove protocols were flawed when states refused to disclose information about execution team training? The decision, she wrote, effectively immunized problematic practices from meaningful review. The ruling meant states could continue using midazolam despite documented failures. It shifted focus from whether protocols worked reliably to whether prisoners could prove better alternatives existed. Justice Breyer, in a separate dissent joined by Justice Ginsburg, questioned whether the death penalty itself remained constitutional. He reviewed evidence of arbitrary application, racial disparities, wrongful convictions, and, relevant to the case at hand, inability to ensure executions occurred without excessive pain. Rather than try to patch up the death penalty's legal wounds one at a time, Breyer wrote, I would ask for full briefing on a more basic question, whether the death penalty violates the Constitution. The court declined that invitation. Capital punishment remained constitutional. States retained authority to execute condemned prisoners using available drugs, even drugs with documented track records of failure. The Glossop decision had practical effects. Oklahoma resumed scheduling executions. Other states proceeded with their protocols despite ongoing drug supply problems. Legal challenges continued, but faced higher burdens of proof. Yet implementation remained difficult. Between the Glossop decision in June 2015 and December 2020, Oklahoma executed 0 people. Drug shortages persisted. Training concerns remained unresolved. Protocol. Litigation continued in lower courts. The Supreme Court had declared Oklahoma's method constitutional, but Oklahoma found itself unable to actually carry it out. This gap between legal authorization and practical capability defined the post-2014 death penalty landscape. States possessed statutory authority to execute. Courts generally upheld that authority. Yet reliable implementation proved elusive. The machinery of execution, literally and figuratively, kept breaking down. State Clemency Board meeting minutes. Record of post-execution policy review. Votes Oklahoma, November 2014. The State Clemency Board convenes to review execution protocols following the Lockett failure. The agenda includes 5 items: IV placement procedures, medical personnel qualifications, contingency plans for failed vein access, witness notification protocols, and drug sourcing transparency. The board hears testimony from corrections officials, medical experts, legal representatives, and victims' family members. Each perspective carries weight. The system must balance finality, humanity, legal requirements, and public accountability. Corrections. Director Robert Patton presents findings from the internal investigation. He identifies 3 primary failures in the Lockett execution. First, the execution team lacked sufficient vein access training. Second, the protocol contained no backup procedures for IV placement failures. Third, covering the injection site with a sheet prevented monitoring staff from detecting the infiltration until drugs had already entered tissue. Patton proposes reforms. All execution team members will undergo enhanced phlebotomy training. The protocol will require visible monitoring of injection sites throughout the procedure. A physician must confirm proper IV placement before drug administration begins. If vein access fails after 45 minutes of attempts, the execution will be postponed and rescheduled. Medical experts testify about midazolam's properties. Some argue the drug cannot reliably produce unconsciousness deep enough for execution purposes. Others maintain that proper dosing and administration can achieve the necessary effect. The testimony reveals fundamental disagreements within the medical community about execution pharmacology. Defense attorneys argue for complete transparency about drug sources and team qualifications. They present evidence that secrecy laws prevent meaningful challenges to potentially flawed procedures. Without knowing where drugs originate or who administers them, courts cannot evaluate whether protocols meet constitutional standards. Prosecutors emphasize finality. Victims' families wait years, sometimes decades, for executions to occur. Stephanie Neiman's family waited 15 years between Lockett's conviction and his botched execution. They still lack full closure because the execution went so poorly. The system owes victims certainty that sentences will be carried out appropriately. The board votes. 4 members support implementing enhanced training requirements. 3 support them, but question whether they address the core problem, unreliable drugs. 2 vote against any protocol changes, arguing the Lockett execution represented a unique confluence of circumstances unlikely to recur. The final resolution passes 5-2. It mandates new training, backup procedures, and monitoring protocols. It does not require drug source disclosure or independent medical oversight. Similar deliberations occur in Ohio, Arizona, Florida. Each state conducts reviews. Each implements some reforms. None fundamentally redesigns its execution system. The changes remain incremental, adjustments to existing frameworks rather than comprehensive reconsideration. Ohio decides to suspend executions until it can secure a reliable drug supply. The suspension continues for years. Arizona conducts its investigation and concludes that while Wood's execution took longer than expected, no evidence indicates he suffered. The state refines its protocols but maintains the same basic drug combination. Florida, having experienced the Diaz failure in 2006, already had reformed protocols in place. The state continues executions with enhanced oversight, but no major procedural changes. These responses illustrate a pattern. Each botched execution prompts investigation and incremental reform. None triggers fundamental system reevaluation. States continue seeking ways to make lethal injection work rather than questioning whether it can work reliably given current constraints. The clemency board meetings reveal the impossible task these bodies face. They must design protocols that satisfy legal requirements, accommodate drug shortages, respect victims' interests, protect condemned prisoners from excessive suffering, and maintain public confidence. No protocol can simultaneously achieve all these goals when reliable execution drugs remain unavailable and medical professionals refuse to participate. DNA laboratory report, forensic results prompting case review. The failures created unexpected opportunities. When executions went wrong, they generated documentation, witness statements, medical records, incident reports, autopsy findings. This documentation enabled legal challenges that might otherwise have failed. Consider how the Lockett execution changed Oklahoma jurisprudence. Before Lockett, courts generally deferred to state assertions that execution protocols worked properly. After Lockett, courts demanded detailed evidence. The execution failure produced a paper trail showing exactly how procedures broke down. Defense attorneys used this documentation in subsequent cases. They could point to specific failures, the number of vein access attempts, the duration of visible distress, the decision points where protocols proved inadequate. These were not abstract arguments about potential problems. They were concrete descriptions of actual failures. The documentation also affected public perception. Media witnesses to the Lockett, McGuire, and Wood executions published detailed accounts. Their descriptions, gasping, convulsions, prolonged durations, conveyed visceral reality that dry legal arguments could not match. Public opinion surveys showed increasing skepticism about lethal injection after 2014. In 3 unrelated cases, inmates received relief based on execution failure evidence. Courts granted stays pending resolution of protocol challenges. Some death sentences were commuted to life without parole. The failures, paradoxically, saved lives. This created an unusual dynamic. Each botched execution made subsequent executions harder to carry out. States faced heightened scrutiny. Courts applied stricter standards. Public support wavered, yet capital punishment remained legal. The theoretical authority to execute persisted even as practical implementation became increasingly difficult. Some states responded by abandoning lethal injection entirely. Nebraska returned to electrocution. Utah offered firing squad as an alternative. Tennessee made the electric chair available if lethal injection drugs were unavailable. These changes reflected acknowledgement that the humane method adopted in the 1970s and 1980s no longer functioned reliably. The quest for more humane execution methods has driven American practice since colonial times. Hanging replaced drawing and quartering. Electrocution replaced hanging. Gas chambers competed with electrocution. Lethal injection replaced all previous methods. Each transition promised to eliminate the problems of its predecessor. Each eventually developed its own problems. The 2006 through 2014 botched executions revealed that no execution method can guarantee reliability when conducted by non-medical personnel using improvised drug protocols. The crisis emerged not from procedural failures that could be corrected through better training, but from structural contradictions that no amount of reform could resolve. Medical ethics prohibit physicians from participating in executions. Pharmaceutical companies refuse to sell drugs for execution purposes. These constraints make reliable lethal injection nearly impossible. States cannot access appropriate drugs or qualified personnel. They must improvise with available resources, leading inevitably to failures like those documented in Oklahoma, Ohio, Arizona, and Florida. Legislative session transcript, state debate over execution moratorium proposals, Pennsylvania, 2015. Governor Tom Wolf announces a moratorium on executions. His statement emphasizes systemic concerns rather than opposition to capital punishment in principle. Pennsylvania's death penalty system exhibits disturbing patterns. Racial disparities in sentencing, inadequate defense representation, wrongful convictions, and now, execution protocol problems. Wolf establishes a task force to study these issues comprehensively. The task force will examine every aspect of capital punishment, from initial charging decisions through execution procedures. Until it completes its review, Pennsylvania will conduct no executions. The announcement draws immediate reactions. Death penalty supporters argue Wolf exceeds his authority. The legislature authorized capital punishment. Juries imposed death sentences. Courts affirmed those sentences. A governor cannot unilaterally suspend the law. Wolf responds that governors possess clemency power under Pennsylvania's Constitution. He is not abolishing the death penalty, merely exercising discretion about its implementation timing. The task force will provide information necessary for informed policy decisions. Similar debates unfold in other states. Oregon Governor Kate Brown imposes a moratorium in 2015. Washington Governor Jay Inslee does the same. California Governor Gavin Newsom follows in 2019. Each governor cites execution protocol problems among multiple concerns. These moratoriums do not require legislative approval. Governors act unilaterally using executive clemency authority. Some issue blanket reprieves for all death row inmates. Others simply decline to sign execution warrants. The practical effect remains identical. No executions occur. The pattern reveals how execution failures translate into policy consequences. Botched executions provide political cover for governors already skeptical of capital punishment. They can frame moratoriums as prudent caution rather than ideological opposition. "We cannot execute reliably, so we will not execute at all," becomes defensible policy. Yet other states move in opposite directions. Oklahoma revises its protocols and resumes executions in 2021. Alabama, Mississippi, and Texas continue executing regularly. The result: growing geographic concentration of capital punishment. A few states account for most executions, while others effectively abandon the practice. This creates disparities unrelated to offense severity. Whether someone faces execution depends less on what they did than where they did it. A murder in Pennsylvania results in life imprisonment. The identical crime in Texas may result in execution. Geography becomes destiny. Federal District Court order, ruling on execution protocol constitutionality, United States District Court for the Middle District of Alabama, February 2022. A federal judge issues a preliminary injunction halting the execution of Alan Eugene Miller. The order cites substantial questions about Alabama's lethal injection protocol following recent execution problems. The opinion reviews Alabama's execution history. On 25th of November, 2021, the state attempted to execute Doyle Lee Ham. Execution team members spent over 2 hours attempting to establish free access. They tried multiple veins in both arms and legs. They punctured Ham's groin area repeatedly. The attempt failed. Ham returned to death row. Ham died of cancer 2 years later, still on death row. An autopsy revealed extensive puncture wounds and tissue damage from the failed execution attempt. Photographs showed bruising covering both arms and legs. On 21 July 2022, Alabama attempted to execute Joe Nathan James. Witnesses reported the execution took over 3 hours from the time James entered the chamber until he was pronounced dead. Most of that time occurred behind closed curtains while execution team members attempted to establish IV access. When curtains finally opened and drugs were administered, James appeared to have injuries on both arms. Alabama maintained that both executions, Ham abandoned and James completed, followed proper protocol. The prolonged duration reflected vein access challenges common in aging inmates with medical conditions. The state insisted no policy changes were necessary. The federal judge disagreed. The order cited the Lockett, McGuire, Wood, and now Ham and James executions as evidence of systematic problems. The record demonstrates that Alabama's execution team has repeatedly struggled to establish venous access, the opinion stated. These are not isolated incidents, but pattern and practice. The judge noted that Alabama, like other states, maintained secrecy about execution team qualifications. No public information existed about training, experience, or medical credentials. The state argued this secrecy protected team members from harassment. The judge acknowledged that concern, but found it insufficient to justify complete opacity. The state asks this court to trust that its execution team possesses adequate qualifications to perform these procedures, the opinion continued. The evidence of repeated failures undermines that trust. The judge ordered Alabama to disclose specific information. Execution team members' training records, protocols for addressing vein access failures, and contingency procedures for prolonged execution attempts. Until Alabama provided this information and demonstrated its protocols could be implemented reliably, executions would remain stayed. Alabama appealed. The 11th Circuit Court of Appeals reversed the district court, finding the state maintained adequate protocols. The Supreme Court declined to review the case. Alabama resumed executions. On 22 September 2022, Alabama executed Alan Miller using nitrogen hypoxia after abandoning the lethal injection attempt. On 26 January 2023, it executed Kenneth Eugene Smith, also by nitrogen hypoxia. Both executions proceeded despite ongoing litigation about whether nitrogen gas constitutes a reliable, humane method. The legal battles continue. Each new execution generates new documentation. Each documentation generates new litigation. The cycle perpetuates itself. State Department of Corrections Policy Memorandum. Updated Execution Procedures, Oklahoma Department of Corrections, October 2021. The agency issues a revised execution protocol incorporating lessons from the Lockett failure. The document spans 47 pages. It addresses every stage from pre-execution medical evaluation through post-execution procedures. Section 3, Venous Access. The execution team shall include at minimum 2 individuals with documented successful completion of advanced phlebotomy training. One team member must demonstrate successful IV placement in at least 50 documented procedures within the preceding 12 months. Section 5, Monitoring. The primary injection site shall remain visible throughout drug administration. No covering shall obscure the insertion point. A designated medical observer shall maintain direct visual contact with the injection site and report any signs of infiltration immediately. Section 8, Contingency Procedures. If venous access cannot be established within 60 minutes of initial attempt, the execution shall be postponed. The warden shall notify the governor's office and the attorney general. A new execution date shall be scheduled no sooner than 30 days following the postponement. Section 11, Drug Verification. All execution drugs shall be obtained from licensed pharmacies operating within the United States. Each drug lot shall be tested by an independent laboratory to verify identity, concentration, and sterility. Test results shall be documented in the execution file. These provisions represent significant reforms. They address specific failures identified in the Lockett case: inadequate training, poor monitoring, lack of contingency plans, uncertain drug quality. Yet implementation questions remain. Can Oklahoma recruit qualified personnel willing to participate in executions? Can it obtain reliable drugs given pharmaceutical company refusals? Can it conduct executions that satisfy both legal requirements and public scrutiny? Oklahoma tests the revised protocol on 28 October 2021. The state executes John Marion Grant. Witnesses report that Grant convulsed and vomited after receiving the first drug. The execution takes approximately 15 minutes, longer than typical but shorter than the Lockett failure. Oklahoma officials declare the protocol successful. Critics argue the visible distress indicates ongoing problems. Oklahoma proceeds with additional executions. Each follows the revised protocol. Each generates documentation. Some go smoothly. Others involve complications described as minor by the state, but troubling by observers. The documentation reveals an uncomfortable truth. Execution protocols can be reformed and improved. Training can be enhanced. Oversight can be strengthened. But the fundamental challenge remains: conducting executions that reliably cause death without excessive suffering while using improvised drug combinations administered by non-medical personnel. Other states observe Oklahoma's experience. Some adopt similar reforms. Others maintain existing protocols. A few suspend executions indefinitely, concluding that reliable implementation cannot be guaranteed. Victim Impact Statement. Family member testimony at clemency hearing. The debates about protocols and procedures sometimes obscure the human stakes. Every execution involves at least 2 sets of victims: those harmed by the original crime and potentially the condemned person if execution goes wrong. Stephanie Neiman's family waited 15 years for Clayton Lockett's execution. When it finally occurred, it went so badly that even supporters of capital punishment questioned whether justice had been served. The family received neither swift closure nor clean resolution. Instead, they witnessed prolonged suffering that sparked national controversy and made their loved one's murder part of an ongoing death penalty debate. Joy Stewart's family attended Dennis McGuire's execution, expecting a brief clinical procedure. They watched him gasp for 26 minutes. Stewart's sister later defended the execution, arguing that her sister's suffering far exceeded McGuire's. Yet the execution's prolonged nature meant the family witnessed distressing scenes they had not anticipated. Deborah and Eugene Dietz's family traveled to Arizona to watch Joseph Wood die. The execution lasted nearly 2 hours. Family members sat in the viewing area throughout, watching Wood gasp hundreds of times. Afterward, they expressed satisfaction that justice was done, but acknowledged the execution took much longer than anyone expected. These families deserve consideration in any death penalty discussion. They did not choose to become part of these cases. Violence thrust them into a legal system they had no reason to engage with previously. Years or decades later, they attend executions hoping for closure. When executions go smoothly, families often report feeling that a chapter has closed. When executions fail or become prolonged ordeals, families face new trauma. They witness suffering. They become subjects of media attention. Their private grief becomes public spectacle. The families of the condemned face different but real anguish. Whatever crime their relative committed, they love that person. They visit during years of death row confinement. They attend legal proceedings. They wait for execution dates. When an execution is botched, they watch someone they care about suffer visibly. Rommel Broom's family witnessed 2 hours of failed needle insertions. Clayton Lockett's family saw him convulse and speak while supposedly unconscious. These images remain with family members permanently. Balancing these competing interests, justice for victims, humane treatment of the condemned, finality for families on both sides, creates impossible tensions. No, execution protocol can satisfy everyone. Every decision prioritizes some interests over others. The botched executions of 2006 through 2014 forced recognition of these tensions. Previous executions occurred quietly, efficiently, with minimal public attention. The failures made the process visible. That visibility sparked questions about whether current practices serve anyone's interests adequately. 8th November, 2025. The Death Penalty Information Center releases its annual report. The statistics tell a story of dramatic decline. 23 American executions occurred this year. 10 states conducted them. 5 states account for over 80% of the total. The report documents continuing problems. 3 executions this year involved complications, prolonged durations, visible distress, or procedural difficulties. The rate of problematic executions remains higher than in any decade before 2014. 31 states retain capital punishment statutes. 23 conducted no executions this year. Some maintain formal moratoriums, others cannot obtain drugs. Many face ongoing litigation about protocol constitutionality. The gap between statutory authorization and practical implementation has never been wider. Death row populations decline. Some inmates die of natural causes after decades of confinement. Others receive resentencing to life without parole. Executions remove relatively few people from death row compared to other forms of removal. The report includes a section on botched executions. It defines the term, an execution in which there is a delay or problem in the process that causes, at least arguably, unnecessary agony for the prisoner or that reflects gross incompetence of the executioner. By this definition, 3% of all executions since 1977 have been botched. Between 2014 and 2025, the rate increased to 7%. The numbers do not capture the full impact. Each botched execution generates litigation affecting multiple cases. Each failure strengthens legal challenges to execution protocols. Each visible problem erodes public confidence in the system's reliability. Pharmaceutical companies maintain their refusal to sell execution drugs. Medical professional organizations continue their ethical prohibitions on participation. These constraints force states to improvise. Improvisation produces failures. Failures generate scrutiny. Scrutiny makes implementation harder. The cycle continues. Some observers predict capital punishment will disappear gradually through practical inability to implement rather than formal abolition. States will retain death penalty statutes but conduct no executions. Death row will become de facto life imprisonment. Others anticipate innovations, new drugs, new methods, renewed public support following heinous crimes. They argue the current crisis reflects temporary supply problems, not fundamental systemic flaws. The 7 botched executions examined here, Diaz, Broom, McGuire, Lockett, Wood, Ham, and James, changed American death penalty practice permanently. They demonstrated that execution failures were not isolated aberrations, but predictable consequences of structural constraints. The cases produced documentation. The documentation enabled litigation. The litigation generated policy changes. The changes did not solve underlying problems, but shifted their nature. A line from the Oklahoma investigation report remains relevant. The protocol assumed successful IV placement. It contained no contingency procedures for access failure. That sentence describes not just one state's execution procedure, but the entire modern American death penalty system, designed for ideal conditions, unable to adapt when reality diverges from expectation. The families of victims deserve justice. The condemned deserve humane treatment. Society deserves a system that functions reliably and ethically. Reconciling these requirements grows more difficult as the practical constraints tighten. The documentary record continues. Each execution generates reports, witness statements, medical findings, legal opinions. Each document adds to the accumulated evidence about whether American states possess the capacity to execute consistently with constitutional requirements and basic human dignity standards. The answer, increasingly, appears to be no. Not because states lack commitment or resources, but because the structural prerequisites for reliable execution no longer exist. When qualified medical personnel refuse to participate and pharmaceutical companies refuse to supply appropriate drugs, no amount of protocol reform can guarantee humane implementation. 16th November 2025. The Oklahoma Supreme Court issues a ruling on whether the state's revised execution protocol satisfies constitutional requirements. The opinion runs 87 pages. It reviews the Lockett failure extensively. It examines the revised procedures. It ultimately upholds the protocol. The final paragraph concludes, the state has demonstrated reasonable steps to address identified problems. While no execution protocol can eliminate all risk of complications, the revised procedures satisfy the Eighth Amendment's requirement that punishments not be cruel and unusual. 3 justices dissent. They argue that the inability to obtain reliable drugs and qualified personnel makes constitutional execution impossible regardless of protocol quality. We have created an elaborate regulatory framework for a process we lack the means to implement properly. The dissent states, the case record remains open. More executions will occur. Some will proceed smoothly. Others will fail. The documentation will grow. And the fundamental question will persist, whether American states can execute in ways that satisfy legal, ethical, and human requirements given current constraints. The answer matters to victims' families waiting for justice, to condemned prisoners facing execution, to society deciding what values its punishment system reflects. The botched executions of 2006 through 2025 forced confrontation with questions the system previously avoided. Those questions remain unanswered.